Okay, so we'll get started. Thanks everyone for joining us today with with Legal Services of Long Island and the Community Service Society. Today we are presenting Big Changes, Big Decisions, Navigating Student Loans in Uncertain Times. I'm Sharon Campo, supervising attorney here at Legal Services of Long Island, and we have with us today Nancy Meerman, who is with the EDCAP program, the Education Debt Consumer Assistance Program of the Consumer uh, Service Society. I probably messed up the name. I'm sorry. Um, we're happy to have you with us today, Nancy.
Thank you.
So if you go to the next slide, please. So this is our agenda for today. So we'll just talk a little bit more about Legal Services of Long Island for those who aren't as familiar about us. And then we'll pass it off to Nancy, who will go through the most recent student loan updates. Just a few reminders, if you could keep yourself on mute, that's way we don't have any background noise. If you do have any questions, we will definitely be going over those. You can put them in the chat, and if we can't address them in the chat, then Nancy will be taking breaks here and there to review any questions that you may have. And also, we're going to do a few polls just to keep it interesting. And then if you don't mind doing the survey at the end of the presentation when you close out Zoom, we'd really appreciate that. Next slide. So if you're unfamiliar with Legal Services of Long Island, we did change our name from NASA Suffolk Law Services to Legal Services of Long Island. We did that back in September, but we are Long Island's largest provider of civil legal services for free. We handle over 6,000 legal cases every year, and that includes direct representation, phone consultations, brief service, referrals. We do have offices in Hempstead, Islandia, and Riverhead. And our case handling staff includes attorneys, paralegals, and social workers. And we have partnerships with community agencies, whether it's Empire Justice Center or the Community Service Society or Brighter Tomorrows. So we have many different partnerships. Next slide. And these are our three offices. We have Hempstead, Islandia, and Riverhead. We do accept walk-ins. We do prefer clients to call, if possible, our phone number of the office that's closest to them. So obviously, Nassau County residents, please contact Hempstead, and Suffolk County residents, please go to Islandia or Riverhead. We do have a unit specifically dedicated to student loans. So please you can call any of the three numbers, but the 516 numbers that we post for that unit. And then our website is legalservicesli.org. We do have you can go forward one.
Sorry.
That's okay. We do have about 20 different units in the various areas of law, whether it's family law, domestic violence, child support defense in Suffolk County. We have a variety of disability and health related projects, including for folks who are severely mentally ill, our education and disability rights, our disability advocacy project. We have housing units across all three offices that assist with eviction prevention for tenants, or foreclosure prevention projects, and then other units based on areas of law or a certain population, such as veterans' rights, public benefits, our consumer debt project, which I supervise here in Suffolk County. And then we also have a senior citizen law project in Nassau County. So we have a lot of different projects. If you want more details on those, you can go to our website, and we do have details of all of the different projects. And if you go forward one, or if you are an advocate, you can also call our Legal Support Center for Advocates, which is specifically for folks who work at nonprofits and have a client who's struggling with a legal issue, or you're not even a nonprofit, you could be volunteering for your church or your government agency. So anyone who is an advocate, who has a client, a social worker at a hospital, and the client has a legal need, you can give us a call and see if we can assist, whether it's one of our units can assist, or whether maybe we can just give you some general legal information for that client or give a referral. We do provide training, such as what we have today. We publish our newsletter, either in print, and also I send out monthly emails with advocacy tips. You can call either myself, Kathy Lucidi, or Hannah Fitzpatrick. We do ask that you please don't send your clients to us because your client won't be getting services from us because we're not case handlers. I do get sometimes I get phone calls or emails from clients because the advocate gave them our personal information, but we're not case handlers. So it's going to be it's going to be longer to get services. If the best way for them to get services is to call our reception. Okay, so just quick survey here. Okay, if I can grab this survey. Just if I can find it. Here we go. Okay, so the first question is, have you ever called the Legal Support Center for Advocates? If you just take a moment to answer that question, I'd appreciate it. Okay, a few more seconds. Okay, so I'm going to end the poll. So it seems as majority of you have not heard of the Legal Support Center for Advocates. So welcome. Please, if you're an advocate, please feel free to give us a call. We love helping out the community. All right, so I'll just share those results. And then the next question is, what type of advocate are you? And if you're not an advocate, that's okay. You know, this presentation is geared for folks who have student loans as well. So don't worry about it. Okay, a few more seconds. Okay, let's share the results. All right, so it looks like we have a lot of nonprofit employees on here, social workers, attorneys, some paralegal students. So welcome to our presentation. I hope you continue coming. And then the last question is just about student loans. I think I didn't launch that yet. Hold on one second. Okay, here we go. The student loan question. Now, I know I have student loans, which hopefully will be discharged soon through the Public Service Loan Forgiveness Program. That is the 10-year goal, which happened 10 years ago.
It's still happening for some people.
It's still
So
happening. Yep. Hopefully soon. Okay, a few more seconds. Okay, I'll end the poll and share the results. So it looks like majority of folks here have student loans, and then some are assisting people for student loans, and some are here just to learn, which is absolutely fine. So thank you so much for joining us, and let me stop sharing that, and I'm going to pass it off to Nancy.
okay. Thank you, Sharon. And thank you again to Legal Services of Long Island for allowing me to host this very important presentation. As Sharon mentioned, I'm going to be doing the presentation, and we'll have somebody behind the scenes answering questions in the chat. I believe I saw that Vivian Storm has joined. So Vivian, that's probably going to be you.
Yes.
Well, thank you. I will break periodically to ask Vivian to see if there are any questions that merits sharing with the rest of the group, or anything that is unanswered. So with that, I'm just going to turn my video off if I can figure out how to do it. Well, maybe I won't. Okay. We're just going to get right into the guts of the presentation. So we're going to start with some important updates. So the first couple of updates that we're talking about have to do with the Department of Education and really kind of the efforts behind the current administration to eliminate the Department of Education, which has not been eliminated to date. But basically, the workforce has been cut in half, probably a little bit more right now if you include all the people that just have left in the wake of the current administration. And these reductions have really gutted offices like the Ombudsman's Group, where we, during the Biden administration, we had a lot of contact with them and they were able to help resolve various student loan issues. That's kind of shut down at this point. Or they're there in theory, but they're just not a lot of activity going on. And despite the fact that there was a court order a few weeks ago that restored, that ordered the department to reinstate these fired employees, our understanding is that these folks were perhaps put back on the payroll, but are not actually doing any work. And of course, the administration appealed that decision right away. So one of the reasons that we bring this up is because there are alternative ways to file complaints. If you're not, you should still continue to file complaints if you have them through the Ombudsman's office or through the Federal Student Aid portal. But if you're not getting anywhere, in New York State, the Department of Financial Services, DFS, oversees student loan servicers. So you can file complaints with them. And there's a link here when you get the deck to their complaint portal. The Student Borrower Protection Center also recently, or actually after the election, created a toolkit for borrowers to submit complaints through their elected officials. This should probably be your more difficult problems, but there's a process for doing this, and you can click into the SBC toolkit to understand how to go about doing that. Of course, the other thing we want to talk about is the announcement that the plan was to transfer the management of the student loan portfolio to the Small Business Administration. This announcement was made in February. The president said it was going to happen immediately, and it has not happened. Our understanding is that they cannot do this without congressional approval. I also believe that in the Senate budget reconciliation bill, they've written something in there that potentially would pave the way for allowing them to do this, but we'll have to wait and see whether or not that gets approved or not. If they don't, chances are this may not happen at all. But the key thing that you need to know is if the management or the oversight of the loans is transferred to the Small Business Administration, nothing changes about your loan. So the loan amounts don't change, the interest rates don't change, the forgiveness programs, the payment options don't change just because the management shifts to the Small Business Administration. Federal student loan collection. So this was a big announcement that first came out in April, and then there was a little bit of backtracking on that. But they basically have announced that the Department of Education is going to resume collections. So remember, collections on the vast majority of federal student debt have been suspended for about 4.5, close to 5 years now. They were pretty much suspended all throughout COVID and then beyond. So this was inevitable that this was going to happen regardless of the administration, frankly. But the announcement was made in April that the department would start collections initially offsetting with Treasury offsets that would be against federal benefits like Social Security or tax refund intercepts. Now, in June, the department backed off of doing collections on Social Security. In fact, I just heard a message from the debt collection arm yesterday that says that the collections on Social Security are paused for a couple of months, but they are probably going to resume later this summer. So anybody that's defaulted and is on Social Security, you should take this pause as a time to go ahead and try to address the default. We're going to be talking more about that later. It's approximately 5.5 million borrowers are already in default, and these are people that probably were in default prior to COVID and just never came out of default. But there's also another 4 to 5 million borrowers, it is estimated, that are significantly delinquent and could in the next several months be at risk of default. We could see 10 million or more borrowers in default by the end of the year, and that's close to 25% of the total federal student loan portfolio. So this is clearly a big issue. If you're if you filed your 2024 taxes and you've already received your refund and you're in default, you are not going to be at risk of losing that refund. But if you haven't filed your taxes or you filed them and you haven't received that refund, you could be at risk. And administrative wage garnishment, those notices are probably going to go out later this summer, and we would expect collection activity sometime in the fall. So now's the time, if you're in default, to start addressing this before collections really kick in. For some people, they may have already kicked in the form of tax refund intercepts. We've also now got the SAVE litigation. This has been going on for a long time. As a reminder, the SAVE plan was that really was going to be the cheapest repayment plan available from the vast majority of student loan borrowers. The Biden administration introduced this in 2023. In July of 2024, an appeals court essentially shut it down, forcing the Department of Education to place everybody that was enrolled in SAVE in a forbearance, which is where most of those people still sit. So that we're still awaiting the final ruling of the court. The Eighth Circuit just ruled again in February, has remanded this case back to the lower courts, and we're just waiting for a decision from the lower courts, which we would have assumed in a lot of cases that this would have been done already, but it's not. We don't know exactly when it's going to happen. So what this all means is that if you were enrolled in SAVE back in July of last year and you haven't taken steps to get out of that plan, you're still in a non-interest bearing forbearance, which is a good thing. You're not required to make a payment, no interest is accruing, but it also doesn't count towards forgiveness. That forbearance has recently been extended to October 31st, 2025. Remember, the forbearance is really there until the court case is resolved. So if the court case is not resolved by October 31st, or if there aren't new rules as a result of budget reconciliation, that forbearance could be extended once again. So you just have to, we'll talk more about what you should or shouldn't do depending on what your circumstances are. If you're interested in getting out of the SAVE plan, the online IDR applications are available. And after a long period where they weren't processing anything, they are actually starting to process these applications right now. There's a backlog. It looks like the backlog is probably going to be at least 6 months. Doesn't mean that it's going to take you that long to get the application processed, but you should expect some delays. But IDR forgiveness, that's the forgiveness if you're enrolled in any one of the income-driven repayment plans that allows you to get your loans forgiven after 20 or 25 years. There's no employment requirement for that forgiveness plan. That program seems to be on hold right now for all plans, even though it probably should be. They should be doing it in one of the plans, and we'll talk a little bit more about that later, but they're not for now. Although we do anticipate that they'll start up that program again, at least in the income-based repayment plan. But PSLF, as we were talking about earlier, is still there. Nothing has changed, even though there's an effort to make some changes to qualifying employers. That hasn't happened yet. So if you were eligible for PSLF a month ago, you're still eligible. And borrowers who are not in the SAVE plan can continue making payments in your other income-driven repayment plans and earn credit towards PSLF. Recertification guidance, as you probably know, if you're in any one of the income-driven repayment plans, and when I say income-driven or IDR, that's an umbrella term for 4 different plans. It includes SAVE, it includes pay-as-you-earn, it includes income-based repayment or IBR, and also ICR. If you're in any one of these plans, under normal circumstances, you would have to recertify these plans every year. But due to COVID and because of the SAVE forbearance, these recertification dates kept getting pushed back. However, back in February, there was a period of about a month or more where people were being asked to recertify their IDR plans by either February 20th or February 21st. However, the servicers were not processing any of the IDR applications, and what was happening was not so much that people were getting kicked out of their plans, but their payments were being reset to a very high level, really the equivalent of the standard 10-year fixed repayment plan. And then they weren't able to make those payments, and it was a lot of confusion. Long story short, the department finally came out with some recertification guidance. I'm not going to go over everything here. You can read this in detail and see which category you fit into. The only thing I will point out is that if you were supposed to submit your application by February 20th and you didn't do that, or you did do it and your payment was reset, you're going to have to resubmit a recertification application in order to get that corrected. In all of these other circumstances, the servicers were supposed to go back, correct all the IDR payments, revert you back to what you were supposed to be paying, and extend your recertification date. For the vast majority of borrowers, these are people with Department of Education held loans, direct loans, and certain FFELP loans. You're not going to have to recertify before February of 2026. But if you're in one of those areas where it never got corrected, or one where you had to redo your recertification application, you need to stay on top of that, monitor your servicer account, and make sure you're in the right status and with the right payment. So let's talk about the potential changes coming down the pipe, because there are potentially some very significant changes. First, we've got the legal challenges. So this is a legal challenge to the SAVE plan predominantly, but it's also including some regulations that were put in place at the time that SAVE was put in place. So they're referred to as the SAVE regulations. However, some of them actually do affect other income-driven repayment plans, like automatic IDR recertification, or whether or not you get any retroactive credit towards IDR forgiveness if you consolidate. Now, PSLF, by the way, has a different set of rules. It's a different law. And the court ruling really has no bearing on PSLF itself. However, it does have a bearing on the income-driven repayment plans that people use to achieve PSLF. So one of the determinations that the court might wind up making is that IDR forgiveness in SAVE, which frankly is probably likely to go away, or payee or ICR is even going to be an authorized program any longer, which is one of the reasons why they're not processing IDR forgiveness, certainly in those plans, because they're awaiting the court ruling. The IBR plan is the only one of the income-driven repayment plans that's in statute. So the legal challenges really don't impact the IBR plan all that much directly, which means that in theory, they could be allowing people to get IDR forgiveness in IBR, but they're just not processing those applications right now. Beyond the legal challenges, however, there's a couple of other things going on. The big one being, of course, the budget reconciliation bill that's happening with Congress, and then something called negotiated rulemaking, which is a Department of Education process that they use to make changes to certain regulations. So the proposals, and most of them are really coming through the budget reconciliation bill, could really reshape the way you pay back student loans going forward. So what they're proposing for future borrowers is just two options: one version of the standard fixed repayment plan with a payment period ranging from 10 to 25 years, depending on your debt size, or a new income-driven repayment plan called WRAP, that would be eligible for PSLF, that would also offer forgiveness, but only after 30 years in comparison to 20 or 25 years for the current IDR plans. So that would be a significant shift in limiting all those options. They're also that budget reconciliation bill would eliminate the payee and the ICR plans. It would also eliminate the SAVE plan if it still exists at that time. They're also talking about sunsetting up the PLUS loan program for graduate students. PLUS loans allow you to borrow up to the cost of attendance, which allows graduate students to fund expensive graduate plan, master's and professional degrees, and stay within the federal student loan system. But they're talking about eliminating that program, which would mean that borrowers would have to kind of resort to either finding cheaper schools, paying out of their own resources, or going towards private loans to fund the excess. They're also talking about putting on some, in certain circumstances, pretty significant limits on Parent Plus borrowing. And then the negotiated rulemaking committee seems to be focused on changing some of the PSLF eligible employer rules, and that's ongoing right now. There looks like they're fast tracking this now. When it would actually be implemented, once they make a decision, still would be a little while, not immediately, but there could be some changes coming down the pike from that. There's not a lot of changes proposed in the budget reconciliation bill towards PSLF. So PSLF is going to be around in one form or another. We just have to see what comes out as a result of the negotiated rulemaking bill and whether or not whatever they come up with winds up being challenged. So what should you do? Well, we're going to go into a little bit more specifics later on, depending on your circumstance. But the one big key takeaway, because we're in such a period of flux, is keep track of your own records. Don't rely on federal student aid. With the downsizing of the Department of Education, not only have they lost their ombudsman's group, but they've lost a lot of people in the technology area. So those people that are responsible for maintaining the FSA website. So you don't want to rely wholly on them or your servicers to maintain accurate records all the time. So what we're recommending to our clients is that you start downloading and screenshotting important information on a regular basis. So this would be things like loan details from your federal student aid and your servicer account, payment history that you would get from your servicer account, information from the PSLF tracker from FSA if you have one, and any important notifications in your servicer inbox. So you want to do this monthly or whenever you get some kind of a notice that your loans are going to be transferred to a different servicer, or maybe down the road to the SBA. Okay. I'm going to move on to the next section and go through this before we break for any questions, because I want to make sure I get through everything. So we're going to talk a little bit about strategy, the different ways that you can pay off your student loans. And from our experience of working with thousands of clients since 2019, since the EDCAP program was launched, we have found that most borrowers will fit into one of three categories when it comes to determining their long-term strategy. So people come to us, of course, often because they have an immediate issue. They can't afford their repayment plan, or they're about to default, or they're in default and they want to get out of default. And we always, of course, address those immediate needs, but we also always want to leave our clients with a long-term strategy for eliminating the debt, because at the end of the day, that's your goal, is to eliminate the debt. So people generally are going to fall into one of three buckets. The first one is to pay the debt in full as quickly as possible. So that's going to be best suited for people who have high income in comparison to their loan balances. They can afford to make extra payments on a monthly basis, or they can afford to maybe make lump sum payments from time to time. If this is your strategy, you want to pay it off as quickly as possible. The less time it takes you to pay it off, even though you may wind up making higher payments, the less you'll pay overall over the life of the loan, because you're saving on interest. The second bucket is where most of our clients fall, and probably most of you who are listening in on this, is that you're identifying a forgiveness program that is best suited for you, which in a lot of cases is public service loan forgiveness, which would get your loans forgiven in 10 years, or IDR forgiveness, which can get your loans forgiven in 20 or 25 years. You've identified that forgiveness program, and you just want to make the minimum required payment until such time as you get forgiveness. Now, again, this is going to be best suited for people who have high balances, low to moderate incomes, or may be pursuing one of these forgiveness programs. If this is your strategy, it doesn't make a lot of sense to make extra payments on the loan, because you're not really going to be paying off the entire debt. You're just going to be paying the minimums until you meet the requirements of the forgiveness program to get the loans discharged. And then the final bucket is, which sounds a little bit depressing, but we have it here for a reason, is to pay the minimum required until death do you part. So this is generally going to be for older borrowers who maybe took out late in life loans for themselves or took out Parent Plus loans for their kids, and now they're in their 60s or 70s. They may be, right at about to retire or in retirement, so they can't really take advantage any longer of things like public service loan forgiveness. And they just are faced with paying the debt back. It could be for 20 or 30 years. And when you're 50 or 60 or 70, that could be for the rest of your life. So the goal here is just to find the cheapest repayment plan that you can find, make those payments, and understand that when you pass, unlike most other types of consumer debt, the federal student loans do not pass down to your estate. So basically, they're discharged in death, and they don't become a burden for your loved ones. Okay, so in terms of repayment options, there are basically two different ways to make your payments in the federal student loan system. There are the traditional plans where the payments are based on the size of the debt, the interest rate, and a predetermined payback period. And the fixed versions of these plans are just like paying back any kind of regular consumer loan. So it's like paying back a mortgage or an auto loan. You make the monthly payment over the time prescribed, and after you've made all the payments, you've paid the entire debt off, including all of the interest. Now, if you can't afford the traditional plans, which a lot of people can't, particularly if you're just coming out of school and you have a significant amount of debt and you don't necessarily have the job that you hope to have eventually, or your profession just doesn't pay that well, the alternative is to enroll in an income-driven repayment plan, or IDR plan. Again, that's the umbrella term for the 4 plans that we discussed earlier. That's going to provide, in most cases, an affordable alternative to the traditional plans. These plans also offer loan forgiveness after 20 or 25 years. That's the IDR forgiveness that we talked about a little while ago. You are required to be in these plans for certain types of forgiveness programs like PSLF or IDR forgiveness. And of course, you can adjust the payments if your income declines in between your recertification dates. You can have the plans recalculated and the payment will be adjusted so that you're never having to make a payment that's based on an income that you no longer have. So there's pros and cons of each. It very much depends on your strategy. Of course, one of the downsides to IDR plans is that you do have this annual administrative thing that you have to do by recertifying every year, whereas on the traditional plans, you don't have that. So you're just in the plan and the schedule is the schedule. So it's easier to manage that way. In the income-driven repayment plans, and this has been the big kind of beef that a lot of people have about federal student loans, is if your payment does not cover the interest that accrues every month, in all these plans except for the save plan, the unpaid interest will accrue. And that's why people complain about, I'm making my payments, I made my payments every month for 10, 20 years, and the loan balance is going up. And that's very disconcerting, although most of those people should be pursuing a forgiveness program, which means that you're not looking to pay off the entire debt. Nevertheless, it's very difficult to look at that and see the loan balance mushroom while you're attempting to pay it. The names of the traditional plans, by the way, if you see something called standard, extended, graduated, or if you look on your servicer account and it says level plan, that would be some form of a traditional repayment plan. I did want to say a few words about income-driven repayment forgiveness. Again, this is the 20 to 25-year forgiveness that you get for being in an income-driven repayment plan. So this is going to be the default forgiveness program for people who have large loan balances, moderate incomes, but they don't have the kind of employment that would make them eligible for things like PSLF. So the Biden administration had something called the IDR account adjustment, where they gave retroactive credit towards IDR forgiveness, which, by the way, can be turned into PSLF credit if you file the PSLF certification forms. But they gave this credit based on a relaxed set of rules. That plan pretty much ended last year. And for a brief period of time, the Department of Education in early January had posted a tracker on the federal student aid website that gave you all the information about where you were in the IDR forgiveness. You know, it gave you a snapshot of your progress towards IDR forgiveness, told you how many qualifying payments you needed, how many you had, and that therefore people kind of knew where they stood. So that tracker was available for about a month and a half, and then it was taken down. Now, I just literally read earlier today that it's possible that they're going to be putting these trackers back on the federal student aid account. But for now, you should know that the information, just because the tracker is no longer there, is not gone from the system. And there's this, what we call a backdoor link, a way of getting that information, at least a portion of it, out of the system. You want to log into your federal student aid account at studentaid.gov, open up a separate tab in the same browser, and then once you get this deck, you would put this link in there, and it's going to come up with this ugly looking file over here to the right. You want to click the pretty print box at the top, which this is the pretty print display. If you don't click that, it's going to be even uglier than what you see here. You want to either download that or copy and paste it into a document and save it. Even though you may not be able to read it, people like us, people like the folks at LSLI can read it. That's your information. If they don't put the trackers back up, you would at least have access to a summary of where you are in the IDRF process. And just as a reminder, the SAVE litigation may determine that payments, you can no longer get IDR forgiveness in payee or SAVE or ICR. If they do, and you've accumulated credit in those plans, it can be transferred to the income-based repayment plan, assuming you're eligible for that plan, and you will not lose that credit that you've already generated or you're already accumulated. Okay, before we move on, Vivian, I'm going to stop there and see if there's any questions we want to kind of share with the group or you need to ask.
Yes, there were a number of questions. I answered them in the chat, but I just want to go through it because I think there's some that we might want to spend some more time on. One question is about PSLF buyback, which you may be getting to later in the presentation.
Yeah, I am going to cover that. So maybe we want to put that aside for now.
Okay. Next is whether people who are on an IDR plan or were on SAVE should be considering switching to another plan at this point.
So actually, we're going to cover that as well when I go forward. So maybe we're just going to maybe table some of these questions.
Yes. Yeah, I think
and then I'll come back to them if they're still unanswered. But if there's anything in terms of what we've covered already.
No, I think we're good. Thank you.
Okay, good. So I just want to, in the interest of time, I want to make sure we get through everything, but we'll definitely answer your questions. So let's talk about PSLF. So Public Service Loan Forgiveness, as I think most of you probably know, forgives loans after making 120 qualifying months or 10 years of qualifying payments. And a qualifying payment is defined as an on-time payment made in full on or after October 1st of 2007. So this is when the PSLF program began. Anything before then, even if you had qualifying employment before then, it just doesn't count towards PSLF. Those payments have to be made on direct loans. You must be in an income-driven repayment plan, or payments in the standard 10-year fixed repayment plan will count as well. Now, in most cases, you can't really be in the standard 10-year fixed plan for the whole 10 years, or else you'd pay the debt off and there would be nothing left to forgive. So at some stage, you generally have to be in an IDR plan. And then, of course, you must meet the employment requirements of the program, which is that you have to work at least an average of 30 hours per week or more for one or more qualifying employers concurrently. And a qualifying employer is generally a nonprofit or a government agency. The payments do not have to be consecutive, so you could be working in public service for 3 years, have 3 years of qualifying payment credit, and then you move to the private sector for a few years. If you decide to come back, you will not lose those 3 years that you've accumulated. And very important that you must meet the employment requirements at the time that you submit the application for forgiveness. So if you're on the brink of retiring, just don't retire until you've submitted that last application. because otherwise you would be in breach of the terms of the program. And then one of the best features about PSLF, unlike some other forgiveness programs within student loans, is that forgiven balances are not taxable at the federal level, and nor are they taxable in New York State. Some states do tax them, like a handful, but not New York State. So the buyback, I know there's probably lots of questions about the buyback. So the PSLF buyback, I should just say, is not part of the original PSLF law. It was part of a set of regulations that were introduced in 2023 that really didn't become relevant until after the IDR account adjustment was over. So a lot of the things that the buyback does was already taken into consideration by the IDR account adjustment that we talked about. However, one of the big things that was not anticipated when they wrote the PSLF buyback rules was the save forbearance. So what the PSLF buyback allows you to do is purchase credit for months that were spent in disqualifying payment statuses. So certain months of forbearance or deferment. And we have recently confirmed, because it was unclear for a while, but time spent in the save forbearance is eligible for the buyback. The bigger question is, how are they going to calculate the payments during those months, because they're not allowed to use the save formula, but that's a different issue. The time spent in the save forbearance is eligible for the PSLF buyback. But in order to be able to do the buyback, a couple of things have to be in place. Number one, you have to have 120 qualifying months of employment on record, not qualifying payments, but employment on record. So that may require that you submit another PSLF certification form when you reach that landmark. And then the months that you purchase must get you to 120 qualifying payments. So as an example, if you have 110 qualifying payments on record and you're at 120 qualifying months of employment, if you only had 5 months to buy back, you wouldn't be able to do the buyback. You must be able to buy back at least 10 months to get you to forgiveness in order for you to submit to be eligible for the buyback. Now, there's a lot of people right now, given the fact that you've been in the save forbearance for like a year, that may well be at the point where you're eligible for this. But just keep in mind that there are certain periods that you cannot buy back. So you cannot buy back months spent in a school deferment, grace period, or default, and you can't buy back months prior to a consolidation. If you think that you're eligible for the buyback, you should absolutely submit the application. It's pretty easy to do. You do it through the PSLF reconsideration portal, and I've got the link to that right here. And when you get into the portal, there's just going to be a tab that says select PSLF buyback. You click that tab and that's it. You don't put any more information in there. You just wait for them to come back to you with a proposal. So you don't get to select which months you want to buy back. They're just going to come back with a proposal. Now, the one thing that everybody needs to be aware of is that apparently processing these buyback applications is very labor intensive. And to the best of our knowledge, they literally maybe have a handful of people working on it, like literally 5 or 6 people. So it's going to take time. And we do have a little bit of an idea now of what's going on with the processing. They've been forced to disclose the PSLF buyback processing as part of the American Federation of Teachers lawsuit. So we just got an update, and in the month of May, they processed 3,300 applications, but they now have a backlog of about 59,000. So they've doubled the amount that they processed, but the backlog is increasing. And just looking at these numbers, you would estimate that it would take them about 1.5 years to get through the backlog. And we imagine that backlog is just going to continue to grow. So by all means, we recommend, if you think you're eligible, you should do it, but just be aware of the fact that there could be a very long delay in actually getting a response. One of the things that you can continue to do now, though, is you can and should continue to submit your employment verification forms. These are the PSLF certification forms. And remember, you want to have you need to submit these forms for every employer that you've had since October 1st of 2007 or later if your loans were dispersed later. Generally speaking, we recommend that you submit the forms annually. There's no deadline for doing it, but you must have one on record in order to get an official qualifying payment count. You want to do it annually or whenever you change jobs. Now, the most important bullet point here is the last one, is that when you submit these forms, and we know this may not be possible in every case, but wherever possible, you want to use the PSLF help tool, which you can access through your FSA account, and you want to request an electronic signature from your employer, which means that you're going to have to provide an email address for the person at the employer who's going to sign off on these applications. Anything submitted with a manual signature these days seems to be languishing for months and may not get processed. So to the extent that you can, you definitely want to use that electronic signature function when submitting these forms. Okay. So on to some guidance for borrowers, and I think this is going to go towards some of the questions that you probably are coming up in the chat. We put together kind of a list of things that you should consider doing and maybe hold, or maybe whether or not you want to hold off depending on your circumstances. So if you're in the save forbearance, and I know we get a lot of clients that are in the save forbearance that just don't know what to do at this point, just remember that no action is required right now. You're not required to make a payment. Interest is not accruing on your account. And if you're not pursuing PSLF, or you're very far away from actually getting PSLF, or you're very far away from getting IDR forgiveness, and you're concerned that you're not going to be able to afford any of the other plans right now, you don't really have to do anything. You may just want to wait a little bit longer, just pile the money up, put it away. Now, if you're planning on paying your debt back, and you're in the save forbearance, you should probably be making payments now because there's no interest accruing on your account. But for all other borrowers, unless you are anxious to get on with accumulating credit towards public service loan forgiveness or IDR forgiveness, you can stay in the save forbearance for now. Even if the court ruling is done before October 31st, honestly, it's going to take, there's about 8 million people are in save, and they're going to have to, we don't anticipate that save is going to survive the litigation. So they're going to have to transition all of these people into new payment plans, and it's going to take them a while to do that. So best guess, and I can't say this for sure, but best guess is that if you're in the save forbearance and you stay there, you're probably not going to have to make a payment before the end of the year. Now, for a lot of our clients, they are anxious to get on with earning credit towards PSLF, and in some instances, they're quite close to PSLF. So here's some guidance there. If you're enrolled in IBR, Payee, or ICR, continue making those payments because you're going to continue to earn credit towards PSLF. If you're on the SAVE plan and you haven't already done so, now you might want to consider filing an application to switch your repayment plans. Now, when you file an IDR application, you should be placed in a processing forbearance. Even if you're in the save forbearance, they would place you in a processing forbearance, which would earn credit towards PSLF for up to 2 months. And then if you're in the save forbearance and and 2 months go by and you're still not, the IDR application is not processed, they'll probably put you right back into the save forbearance, but you would have earned a couple of months of free credit towards PSLF. Again, it could take a while for these IDR applications to process. So my best advice at this point is probably do it online. File the application online. That might be better. It should kind of override whatever other application you might have pending in the system. And then you should submit the buyback application if you're eligible. But if you're close to PSLF, or let's say within a year of PSLF, you might want to cover your bases and not rely solely on the buyback application, because like I said, it could take a long time to get that application, to get a response to that. So if you can afford one of the other repayment plans, switch to a different repayment plan, do the buyback, just wait and see which strategy is going to get you to PSLF quicker. The other thing that you can do, and this is not going to be an option for most people. But if you are eligible and you can afford the payment in the standard 10-year fixed repayment plan, and let's say you're 1 or 2 payments away from PSLF, you can switch to that plan and earn your last couple of payments towards PSLF. But you need to be careful if your loans are consolidated and the balance is above $7,500, you may not be eligible for, well, or you may not be in, you may not be eligible for the standard 10-year fixed repayment plan. It would take some convincing to the servicer to get them to allow you to enroll in that plan. And any of the repayment plans, the fixed repayment plans that have a payback period beyond 10 years is not eligible for PSLF. So this is not going to be an option for most people, frankly, but it could be for you if you're in one of those rare circumstances. If you're in one of the standard plans and you've been trying to enroll in an IDR plan for a long time and you just haven't been able to get in, unfortunately, if you can't afford the payments in the standard plans, you're just going to have to keep monitoring your accounts and request forgiveness, not forgiveness, forbearance until they're able to process your IDR applications. And then if you need to recertify, just double check and make sure that you actually do have to recertify. And then go refer back to the recertification guidance that we gave a little bit earlier. Okay, now I'm going to stop, Vivian, and address any of the questions that pertain to that last section that we didn't answer.
I think everything has been answered by what you just went through. So I'd ask if someone still has some remaining point they want clarified, if you could please put your question into the chat again or revise it.
Okay, great. Actually, I will add one thing to that segment. If you're pursuing PSLF and you're looking to switch repayment plans out of the SAVE forbearance, we've generally been recommending to our clients to select IBR because it's the one plan that is not going to be, it's least susceptible to these, at least the legal challenges. However, there are 2 versions of IBR, and one of them is more expensive than the other, and it depends on when your loan's dispersed as to which one you're eligible for. If payee or ICR are cheaper for you, they still are out there, they still exist. You can switch to those plans, make payments in those plans, and the payments will count towards PSLF. Remember, whatever legal ruling comes down about payee or ICR regarding whether or not you can get IDR forgiveness through those plans doesn't affect your ability to use those plans for PSLF. Now, if the budget reconciliation bill happens and it eliminates those plans, then everybody that's in those plans will have to be moved to a different plan, but we would address that when and if that happened. Okay. So let's move on to total and permanent disability discharge. Just a quick word about this, TPD. The TPD is a program that allows you to forgive or discharge your debt if you have a mental or physical disability that prevents you from engaging in the types of activities that you would need to engage in to maintain like a full-time job. So it's basically a disability that prevents you from earning a livable wage. Doesn't mean that you can't work at all. Doesn't mean that you have to be in a wheelchair or bedridden. It just means that you can't earn enough money really to sustain yourself. So this program has been around for a long time, but they've recently changed the process for filing the applications. So it used to be that you would submit all your TPD paperwork through Nelnet, regardless of where your loans were held. Now they've moved it over to the Department of Education. There's a new page that you can access through the Federal Student Aid website, through the loan forgiveness section, that allows you to submit the application fully online. Or you can get certain things signed off on, like if you're doing it with a medical certification, you would have your doctor sign a manual version of the form, and then you upload those forms to the portal. Or you can also just do everything manually with a PDF and either upload the forms to your FSA account or just mail or fax them in. Now, The one thing right now is it's a little bit unclear as to what's happening with processing of these applications. I know that some of our clients have received letters earlier in June saying that the processing was paused. We're trying to get some clarity on this, but they're still accepting the applications. We're just not sure what's happening with the actual processing. And once you file the application, the loans should be placed into a 6-month forbearance. But you might have to follow up on that with your servicer. Okay, so I do want to talk a little bit about delinquency and default and collections. And this is going to be the last section before we wrap it up. But we haven't had to really deal with this for almost 5 years now. So we'll start off by saying that I know that when the government first made the announcements, because of the way they worded some of the press releases and some of the interviews, it made it sound like anybody that had not been making a payment for a while was going to be subject to collections. That is not the case. You're only subject to collections if your loans are actually in default. So there are different repayment statuses, and just you want to be aware of your repayment status. And if you're not sure, reach out to LSLI, and they can help you kind of interpret that information. But if you're in repayment, even if you're on a $0 repayment plan, you're in repayment, you're not at risk of collections. If you're in deferment or forbearance, any kind of deferment and forbearance is just a means of temporary, giving you a temporary reprieve from making payments, and that includes the say forbearance, but your loans are still in good standing, you're not at risk. If you're in school or in a grace period and you're not making payments, again, your loans are in good standing, you're not at risk of collections. Now, if you're delinquent, you're not at risk necessarily of collections, but if you're in delinquent for too long, you would be at risk of going into default, which would then put you potentially at risk of being faced with involuntary collections. So a delinquency is if you miss one or more payments, you're going to be considered to be delinquent. But if you're delinquent for 270 days or more, so 270 days, that's about the 9-month mark, that's the point at which you may be at risk of going into default. Might not actually happen for another couple of months, but that's the point at which you want to really start to be thinking about taking action so that you're not subject to these involuntary collections. So if your loan is delinquent, what do you do? Again, you're not in default yet, so you still may have a chance to turn this around. You can contact your student loan servicer and ask for a retroactive forbearance. So let's say you've been in forbearance been delinquent since January. You can request that the servicer apply the forbearance all the way back to January. That would bring your account current and would pause your payments for some period of time. Now, asking up for a forbearance or a deferment is a way of just kind of stemming off a default, because it does keep your loans in good standing once you do that. But these are not long-term strategies for managing the debt. So at some point, you're going to have to figure out some kind of payment plan, and you want to explore those options now. And if there's really nothing that you can afford for the time being, you would explore longer term options for forbearance or deferment until such time as maybe your situation changes and you can find an affordable repayment plan or a forgiveness program. Now, what are the consequences of default? If you do go into default after 9 months, the debt becomes payable in full immediately, which of course is typically not possible for most people. You become ineligible for IDR plans, deferments, forbearances, and you can't earn credit towards forgiveness programs, and you cannot access financial aid if you're planning to go back to school and continue your education. So you are also then, if you are in default, subject to involuntary collections. Again, the tax run, the 3 main ways the government is going to go about collecting debt on federal student loans is going to be through tax refund intercepts, through benefits offsets like Social Security offsets. And remember, they can offset regular Social Security retirement and Social Security disability. They can't offset SSI. Or administrative wage garnishment of up to 15% of your disposable pay. So tax refund intercepts may already be underway. Again, if you already filed your 2024 tax returns and got your refund, you're safe, at least for now. But for next year, if you're still in default, might be a problem. If you did not file, or you filed and you did not receive your refund, those could be intercepted, and we have heard that people have gotten those refunds intercepted. Social Security, that's on pause for a couple of months, but they talked about that starting at the end of the summer. Administrative wage garnishment, they're talking about sending those notices out late summer. There are also other ways that the government can intercept funds that are owed to you, if they're owed from things like federal contracts, if you sell federal assets such as treasury bonds, they could actually intercept the proceeds without any warning. And remember, these are federal debts, so the government can do all this without taking you to court. Now, there is these offsets, the Social Security offsets, the tax refund intercepts go through something called the Treasury Offset Program, or TOP. There is a line that you can call, a hotline that you can call. I have provided the number here. If you think you're at risk of collections, you can call that line, and they may tell you whether or not you're scheduled for a collection. Now, the good news is that if you are in default, there are two ways to actually get out of default within the federal student loan system. You can either consolidate your loans or do a loan rehabilitation. I'm going to really do the Reader's Digest abbreviated version of this, but a consolidation just pays off your existing debt, and then your existing defaulted debt, and replaces it with loans that are in good standing, and then you make the payments based on the terms of the new loans. Loan rehabilitation is a longer process. It takes probably 10 to 12 months to complete. You have to make 9 agreed upon payments with your debt collection, the debt collector, over a 10-month period, after which the loans would be rehabilitated. Consolidation is a lot quicker than rehabilitation. Consolidation might be done within 2 to 3 months. Rehabilitation, again, takes 10 to 12 months. Rehabilitation takes more engagement with the debt collector. Consolidation, if you do it online and pay back in an IDR plan, can be done without even talking to the debt collector. Some of the reasons that you might, not everybody's going to be eligible for both of these options. It depends on your situation. But some of the reasons maybe to consider when you're making the decision between loan rehabilitation and consolidation is if you're accumulating credit towards IDR forgiveness, and let's say you have a bunch of credit from the IDR account adjustment. Right now, if you were to consolidate that loan, you would lose all that credit towards IDR forgiveness. It's different for PSLF. Once again, the rules are different for PSLF. You can consolidate loans that have PSLF credit and get weighted average retroactive credit. You just want to make sure that you've got your qualifying payment count updated on all those loans before you do the consolidation. In terms of what stops collections, if you do a loan consolidation, any collection activity would stop upon the loans being consolidated, but you cannot consolidate a loan that has an outstanding administrative wage garnishment. If you do a rehabilitation, it would stop the wage garnishment and any other tax offsets within a 5-month period. Now, if you have a court judgment, which is different than administrative wage garnishment, if you have a court judgment, you cannot do either a consolidation or a rehabilitation. You would have to reach out for some legal help to get that done. And then in terms of contesting an offset or a garnishment, there are ways to do that. Very often, the ways to do that are going to be in the notices that you receive. So you would want to respond to those notices. If you get a Treasury offset notice of Social Security or tax refunds, they generally offer you a hearing within 30 days of the notice. I'm sorry, that's the wage garnishment. You get the 30-day an option of a hearing to prevent a wage garnishment, but you have to respond within 30 days of the notice. For offsets for Treasury offsets, and it's a little bit more of a there's not a specific deadline, but again, you would want to respond to the notice on how to challenge the offset as quickly as possible. And you would want to, in those cases, probably reach out. If you're in default, facing any of this stuff, reach out to LSLI for some help. So that's it. I just do want to make one mention. If you get you get this deck on the relevant links page at the very bottom, EDCAP has a free newsletter that we put out whenever there's an important development. This could be a good way of keeping on top of student loan changes. In addition to that, if you need to reach out for one-on-one services, this is the contact information for Legal Services of Long Island, and they'd be happy to offer you a one-on-one counseling session. So with that, I'm going to stop, Vivian, and I know we're a little bit over, but maybe put it out there to see if there's any unaddressed questions.
I think that we covered all the questions, either in chat responses or through your presentation. So maybe we want to wait just a minute to see if anyone puts anything else into the chat. Otherwise, I think we're all done.
Okay. Well, thank you again. I know this is a lot of information, and this is an ever-changing landscape. You know, in a couple of months, if we come back and do this, could be a whole different set of rules. We don't know. But at least you now know you've got sort of a trusted source to make sure that you're asking people who are going to be as knowledgeable as anybody can get these days on the federal student loan subject. And we're here to help.
Thank you, Nancy. There are no more questions that came in. So people can feel free to reach out to me or to Allison for direct consultation. We're happy to help. Thank you, Nancy, for providing all of this information today.
Okay. Thank you, guys. Everybody stay cool.
Thank
One
you,
more day.
Nancy.
One more day of this stuff.
One more day.
Yeah. Okay.
All right. Stay cool. Bye.
Bye.